who is a lecturer at UPSA Center for Peace and Security with expertise in international affairs, diplomacy and global security. Now, the government is also seeking to fast-track the prosecution of illegal mining cases through the proposed Public Tribunals Bill 2026 as part of efforts to ensure the speedy determination of offences under the Minerals and Mining Act 2006, Act 703. Under the bill, mining-related offences will be subjected to strict timelines from the filing of charges to the hearing of cases and the determination of appeals. The bill requires criminal proceedings to be initiated within 21 days after investigations are completed, with tribunals expected to commence hearings within 15 days after summons have been duly served. Trials are also to proceed on a day-to-day basis until completion, with adjournment allowed only under limited circumstances. The bill further bars stays of proceedings, a provision aimed at preventing delays that have often slowed the prosecution of illegal mining offences. The proposal comes amid growing concerns that prosecutions for illegal mining, commonly known as Galamsey, often remain in the conventional court system for years, undermining efforts to hold offenders accountable and deter environmental destruction. I'm joined on the line now by Deputy Director Operations at Arusha, Ghana, Daryl Bosso. Good afternoon to you, sir. Thank you very much for joining us.
Good afternoon to you as well.
The government is proposing specialized public tribunals to fast-track illegal mining cases, and we know that the bill has already been submitted to Parliament. What's your reaction to this proposal?
Thank you very much. I must say that, yes, we welcome this because for a long time, civil society has been talking about how the judicial system is not prioritizing cases in relation to environment and particularly in relation to illegal mining. So to see that this has begun and with the government and the AG pushing the bill to Parliament is very important. And like you said, I mean, I see this, looking at the bill as it is now, as more of a procedural enhancement of all the existing laws. And when it comes to offences and penalties, there are clear guidelines on that through Act 995. It talks about how who should be fined and what the penalty should be. But there has always been a challenge with how long and the processes that takes place before this prosecution terminates. And it is good to see that this tribunal bill is making some procedural changes, which is going to ensure that a lot of these cases are fast-tracked. I mean, if you look at the provisions now, you are looking at the timeline for disposal of cases within 42 days, and already indicated no still proceedings and also adjournments should all be avoided. But I think that, that said, it still would need to take into consideration a few other things that currently I think it is missing. Because even though it talks about fast-tracking all of these cases, the paneling of the tribunal, we are talking about persons or people who are going to be judges and all of that, I think we need to also see the presence of some environmental aspects, which can then significantly give input into the technicalities of environmental issues and environmental crimes that come up. At the moment, that is not very, very strong in this bill, and this is something that we need to make sure that we look at. Again, there also seems to be a focus on just the criminal punishment or criminal sentences, which is looking at imprisonment and fines. But I wish it would have been good to also include some restorative, environmental restoration actions, also cleanup costs, and even compensation for affected communities. So I think these are things that we really need to look at. Then again, the bill is looking at some environmental principles, but I feel we are still missing key environmental principles like precautionary principle and also polluter pay. They should be very integral to what informs the bill. And I think this is how maybe if you want to make this work, this bill very progressive in actually dealing with the issues, we can really look at it.
You seem to be excited about the timelines given in this bill to ensure a speedy prosecution, as it were, of those accused of engaging in illegal mining. But you also do understand that the Constitution of Ghana allows for individuals accused not to be treated with contempt, as it were. It states that you're innocent until proven guilty. How do you believe that these timelines would ensure that their rights are not abused, as in they would have fair trial even in this limited time?
Well, I think that these cases, or what that requires, first of all, expedient action and expedient justice, because it's in cases of communities being under siege, or, for example, somebody violating environmental regulations. As long as the evidence is there, that is why it is not just about taking the person to court. The bill makes provisions looking at when evidence should be provided, when the prosecution should be ready, and all of that. So it all falls within the scope of the timelines given. And it also gives everyone who is accused, who is arrested, engaged in all of these activities, also time to look at it. So for me, I think it's a crucial aspect. It doesn't take away anybody's right to really defend themselves, and therefore the fact that these cases have rather been fast-tracked we should be very excited about it, because we have seen a lot of situations where people are arrested, they get bail, their cases drag on for long, while they go back and continue to perpetuate the very actions that they were arrested for. So I think nothing about the bill and the provisions and the timelines indicated is indicating that people will not get fair trial because they will not be given opportunity to also defend themselves. Nothing about the bill will indicate that. I think there's procedural arrangement for when the prosecution should file the cases, and this is very much also in line with the Constitution. Nothing has been abused here, and I believe what is important is that everybody works professionally and work diligently and truthfully and with due consideration with human rights associated with all of these processes. So I don't see any problems at the moment with the bill as it is structured.
Let me ask you my last question, two in one, really. Now, if these tribunals are implemented as proposed, do you think faster trials and quicker judgment will serve as a stronger deterrent to illegal miners, and will it even be the big changer, the game changer, as it were, in terms of Ghana's fight against Galamsey?
You know, I think that, what I am rather afraid of is the fact that we will even have this law in place, and yes, still, our state agencies will find a way not to make the process work. But otherwise, if it is made to work as it's really indicated here, then, first of all, it's going to provide the deterrence that is needed, so that when you are caught or when you are found culpable and engaging in illegal activity or in violation of Minerals and Mining Act in any way, you are summarily prosecuted, also as indicated in Act 995. So this particular bill makes proposal rather is to enhance already existing laws and frameworks that we have for a long time taken for granted. So in any case, I think it's going to be better off for all of us to see that justice in relation to issues of violations of environmental-related work or environmental-related laws and all of that are respected, necessary deterrents to let people know that this is one area, if you get into, the law will come after you swiftly. So I think it's very, very important that we see how we can support this. And it is very, very important at the end of the day, when the law is passed, all of us will work with the rule of law and to respect and work diligently to apply the law as it should.
All right, I wanted to hear. Thank you very much, Mr. Bosu, for speaking to us.
Thank you so much.